I hope the speaker from where the person is speaking does not signify his political ideology, or else I would like to shift to that side. Good morning, everybody, my esteemed guests, dignitaries on and off the dais, friends, ladies and gentlemen. I'm overwhelmed, and I do not know where to begin with. Let me start with an honest admission. Despite being deeply impressed by the culture, the heritage, the history, and the language and art of this region, I know very little about it. I was posted in 4 high courts, unfortunately none of them south of Vindhya. And my exposure to this place is principally through some books and as a tourist. I remember Malgudi days where the author says that in Madras, when a student comes home with exam results, the first question asked is, how many marks did you get in mathematics? And when the answer is 98 out of 100, a stern question is asked, where did those 2 marks go? Or through South Indian food, which when I was growing up in Ahmedabad was served in only one restaurant, run by a Marwadi family catering to Gujarati tastes, totally mutilating the authentic taste. So if you ever happen to visit Ahmedabad, please do not visit it. Friends, I accept this award with all the humility at my command. It is a special moment for me and my family. It is special because it is in the memory of an outstanding person, a great legal mind with sense of humor and basically outstanding human qualities. I've known him through Mr. Panchu's dialogues that I've had in the last couple of days, and I've known him through the book that he shared with me. The very fact that on a Sunday morning so many youngsters are present here is a proof of the fact that he touched many lives during his outstanding career. It is special because it came from, the initiation came from Mr. Panchu, one of the most respected senior counsel in the country today. Till recently, when I struck a conversation with him, I did not know him, though I knew of him. And my respect for him had gone several notches higher when he had written open letters in public criticizing certain preferential land allotments to be soon retired judges for setting up mediation centers. He has been a pivotal to all this program from the beginning till the end. He has piloted it. Thank you very much, sir, for including me in this and making me extremely comfortable in the last couple of days. I've had most extraordinary experiences in the last 36 hours or so. Thank you very much for that. It is special because it is given in the hands of Justice Nariman. Outstanding legal brain. He has left his deep imprint on the legal landscape of the country, be it IBC, be it arbitration, be it taxation. He has left his footprint. And more than that, through his words, deeds, and actions, he has shown what courage, what determination, what a single individual can do. Thank you very much, sir, for this. Though so many things are in public knowledge, neither Justice Nariman have spoken nor would I like to, except for saying one thing, that it is a matter of probably one of the greatest satisfaction for me in my entire judicial career of 18 years, that Justice Nariman and others like him trusted my integrity. It is also special because it is for ethics. When I became a judge on 7th of March 2004, I made a promise to myself that at the end of the day, when I demit the office, it would not matter to me if the people said that he was not a brilliant judge, as long as they say that he was as straight as they come. If today I feel, if all of you feel that I've redeemed the pledge that I made 20 years back, it is entirely because of my family. Sonal, my wife, my children, Aparna and Sahil, who had made no demands on me, suffering the judicial and social seclusion for close to 20 years. And my dear friends, who made enormous sacrifices for me, upholding my integrity, my image, making personal sacrifices at all levels. I've been blessed to have several such friends. On any platform like this, the topic of independence of judiciary always comes up. I would like to share a few thoughts with you. I think we need to make some introspection at institutional and personal levels. When it comes to institutional level, I would like to flag two areas, the collegium system and the roster allotment systems. The most ardent supporter of the collegium system would not say it is perfect. And the most bitter critic does not present any viable alternative. We therefore have a situation where, like democracy, though not perfect, is the best system that we have in collegium. But we need improvements. Nobody can deny that. And what are the areas? First of all, we try to have transparency, where the collegium decided to go public about the reasons for acceptance or denial of a candidate. And I think then, and I think now, it was not correct. Because think of a position of a young lawyer who you have tried to persuade to give consent, is publicly told why his candidature is being rejected. He would say, I have not bargained for this, you invited me. Or think of a district judge who is in zone of consideration, who is being bypassed for reasons which are made public. He may have another 5 years in this field to spend. How do we expect him to do that? We also, therefore, this is one area I would park for the moment. The another area is that at the High Court level, the candidate is never taken into confidence as to what is happening to the process. We invite consent from, let's say, about 10 or 15 people. They are shortlisted. Not all 10 will get the recommendation even from the High Court level. Let's say 7 of them get. The 3 are never told that we are not accepting your candidature. They comes to know only when the 7 of them are invited to file formal declarations, and that through the corridors of the High Court. Even when the candidate has consented, his name is recommended, it goes further. For months on end, he has no authentic information as to what's happening. In Rajasthan, a candidate was recommended much before. When I went there, his rejection came finally after 2.5 years. I picked up the phone and called him and said, it is my unpleasant duty to inform you that your candidature has been rejected. He said, I'm thankful for information. One, I'm thankful that it has come to an end. I'm thankful that it is rejected. Now I can plan my life. This is normally not done. The candidate does not even know it's finally rejected. So my suggestion is that every stage, the Chief Justice of the High Court should take the candidates into confidence and tell him about the progress of the process. How far it has reached, where it has gone, what are the leftover stages, has it happened or has it not happened? Is it not unkind to a person who is invited to give consent, sometimes persuaded, he is not even informed that finally he is not being appointed? That's a second area. The third area is the gap between the High Court and the Supreme Court expectations must be bridged. The High Court recommends 10 names, the Supreme Court clears 5. Those candidates who have consented, their faith is diminishing every minute. The High Court and Supreme Court must sit down together and find a way why so many rejections are happening. And one of the thoughts which comes to my mind is that the role of the consulting judges should be reduced. That person has been in the High Court for years to gather his own likes and dislikes and prejudices. The collegium can always consult him informally. The requirement of consultation in writing, in my view, is not a healthy practice. Friends, these are some of the thoughts I have, and I don't claim that they're all correct. Everything has a flip side to it. As I said, the attempt to bring in transparency misfired. But my point, therefore, is that we need a system where we think through all these things and put in place a system which, to the best possible extent, can work more successfully. We missed that golden opportunity in NJAC judgment when the Supreme Court, after striking down the constitutional amendments of the law, left the task of finalizing the MOP to the court, the Supreme Court on the administrative side and the government. In my humble view, that should have been done during the pendency of the petition. Maybe the Supreme Court was concerned about the impasse it had created for more than a year in further movements. But then the first part of the judgment could have been declared, matters could have been kept alive, the Supreme Court could have been in session, and then put in place a system which could have been far more efficient. My humble view is that 3 wise men and women, sometimes 5, are not enough to grapple and grasp all the aspects of the system that needs to be corrected. My suggestion, therefore, would be we should make a platform where we invite not the current judges, but the Chief Justices of the High Court select some of the past judges, social workers, people from civil society, and even the political people. Involve all of them. Make a group of about 20 people. Debate and deliberate all possibilities, positives and negatives and fallouts. Only when we can have a holistic idea of a system which will work best for the entire country. 3 or 5 people simply cannot foresee such complex issues which have far-reaching effect on the national level. On the personal level, on the roster system, a lot of debates are going on. The 4 Supreme Court judges who walked out and gave a public interviews had flagged the idea of one single person not deciding all such important decisions. Friends, in collegium system, the Supreme Court had said that any important decision of this nature cannot be left only to the President or even to the Chief Justice. He must be guided and advised by the collegium of other his colleagues. Why cannot the roster allotment be something similar? Maybe more broad-based, with a veto to the Chief Justice, but not a single person taking all important decisions. It is possible of some outstanding decisions. It is also possible of some mistakes being committed. At the personal level, the judges need 3 qualities to maintain total independence. 1, courage. Nothing in life comes without courage, not judicial independence for sure. 2, spotlessly clean image. If I have some soft underbelly, I'm going to succumb sooner or later to the pressures. And 3, total lack of personal ambition. The only ground on which a person can be corrupted is his personal ambition. Have no personal ambition, you have nothing to fear. And those who are used to playing around people's ambitions do not know how to deal with you. Friends, at the most elementary level, the judicial independence is not all about independence from executive or executive interference. It is far more nuanced. But in simple terms, my basic understanding is that anything, any action, any order, any judgment that a judge takes, which is different from his legal understanding, is going away from judicial independence. Nothing should matter to a judge other than his legal understanding. And if he expresses his legal understanding in his orders, that in my book is totally judicial independence. But at the end, we cannot have independent judiciary without independent bar. An active, vociferous, and fiercely independent bar alone can bring judicial independence. Friends, I would like to share a few more thoughts on other ideas. I was born about 13 years after India became independent. When I was growing up, those existential challenges were still facing the country. External aggression, abject poverty, hunger, unity of the country. The princely states and the princes took a while of persuasion and sometimes force to understand that in modern India, monarchy has no place. The time is up. India had fought 4 wars in quick succession, and war is a costly business. It leaves its impact on the country, on the society, on the economy. So when I was growing up, the nationalistic fervor with cautious optimism was in the air. On occasions like 15th August and 26th January, the speakers would tell us that it has taken many sacrifices of human lives. Millions of people have suffered for this independence to be achieved. Do not ever allow this independence to be frittered away. Do not ever surrender it. Sar kata sakte hain, magar sar jhuka sakte nahi. That was a slogan. Today, more than 7 decades after independence, we do not face those challenges. Due to relative stability, an idea of India has emerged and evolved. An idea of India where there is modern, liberal, scientific outlook. An idea of India where religious freedoms are non-negotiable, where tolerance is a virtue and not a weakness, where social, political, economic justice is a continuous onward march, where diversity is as important as unity, and where federal polity of the Constitution is respected as much as the power of the Union. If I were to speak to young students today on 15th August, I would say, do not allow this idea of India to be mutilated. And it is not as if this idea of India has evolved after independence or even with the advent of Constitution. The movement started much before. It had its roots in Jyotiba Phule's movement for social justice in Maharashtra, or Vinoba Bhave's Bhudan movement, or Dravid movement in Tamil Nadu, or peasants and workers' movements for better protection and better rights. And it has taken several centuries for idea of India to crystallize. It is our duty to protect the idea of India as it stands today. Am I worried about the working of Constitution today? No. Because worried would be too strong a word. But I'm concerned. I'm concerned because our quest for growth ignores environmental impact. I'm concerned because as long as there is double-digit growth rate, we ignore human rights violations. I'm concerned every time there is a fake police encounter. I'm more concerned when such state-sponsored murders are lustily cheered by some sections of the society. I'm concerned when constitutional courts fail to protect the life and liberty of couples on the ground that they are living in immorality. When interfaith couples are not given protection because the marriage is otherwise required to be registered or approved or something, it's not done. I'm concerned when people in living relationship are not protected because the judge thinks what they are doing is corrupting the society. more so when a woman is already married and still living in a relationship. No question is asked whether the man is married or not. Though I'm concerned, I'm not worried because I have this tremendous faith and belief in this country, in its people, that it'll rebound. And my hope is not based on eternal optimism, an eternal optimist though I am. It is based on hard evidence. Because we have seen, when the Constitution of India was being framed, it was under the shadow of some of the grossest possible human rights violations and colossal loss of life and property post and pre-partition. And despite this, when the Constitution was framed, it did not carry any of its rancor and bitterness. It is premised on fraternity and world peace, where protecting the minorities' rights was at the core of many discussions in the Constituent Assembly. We have seen that for about 25 years after introduction of the Constitution, the Supreme Court failed to grasp the mood of the nation and failed to keep pace with the people's expectation of the change of society and social changes. Every time the social changes were brought up, the Supreme Court sided with status quo. We have seen how the movement from within and the exertion of pressure from the public demand, the Supreme Court slowly changed its stand. Justice Matthew, in N. Thomas' judgment, said Article 16(4), Clause 4 of Article 16 is not an exception to equality clause of Clause 1 of Article 16. It is just a more emphatic manner of saying what Sub-Article 1 already says. Because there cannot be equality amongst unequals. We have seen the judgments of Bandhua Mukti Morcha and Hussain Ara Khatun laying a foundation for the public interest litigation jurisdiction to thrive later on. All that we have witnessed, and the onward march goes on. I never give up hope that this country will rebound, and with all its vigor, the idea of India will be protected and it will advance its purpose in all times to come. I thank all of you to remain present here today, Mr. Datar, Justice Indira Banerjee, Mr. Ram, Mr. Advocate General, all of you who make your presence here make very special for me. Friends, at a certain stage in life, you look back, and the question that is uppermost in your mind is, did I live a good life? The answer should come from others, not you. Thank you so much.